welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about one particular aspect of asylum. Now, when you're applying for asylum, there's a law that says if you have firmly resettled in a third country, then you're not eligible for asylum in the United States. Now, of course, there are these new regulations by Trump regarding if you pass through a third country, you have to apply for asylum there before you get to the U.S. That's not what I'm referring to. I'm referring to, let's say, for example, that you're coming from some country in Africa who you're clearly being persecuted because of your, religious background or your political affiliations or whatever the case may be. Let's just say, for argument's sake, you have a great asylum case. Now, let's say you left Africa, the particular country 4 years ago, and you went to England. Okay. And let's say you went to England for the last 5 years and you obtained residency in England, all with the intention to ultimately get to the U.S. And let's say then after 4 or 5 years and you have permanent residency in England, you come to the U.S. and you apply for asylum. Well, that's not going to work. You'll never be granted asylum in the U.S. because you obtained residency in a third country. Okay. So firm resettlement certainly bars anyone who has obtained residency or citizenship in the third country. The theory is that the reason for asylum is to protect someone who's running from their home country from persecution. And if you have actually received protection from another country, such in my example, such as London, then you no longer need asylum because, basically you're not being persecuted anymore. You can just stay in London the rest of your life, no problem. Now, let me give you another example. Let's say the same thing. You come from some country in Africa, you have a great asylum case, you go to London, but let's say this time you stay there 4 years, but let's say this particular time you don't get residency there. You're only there either A, on a work permit, or B, on a student visa, whatever their equivalent of a student visa or work permit is. And let's say that after 4 years, you either finished college or you finished your work and your work visa is no longer valid. And then you come to the U.S. Well, in that case, excuse me. See, this is a live video. In that case, you would be able to apply for asylum because there would be a very good argument that there was no firm resettlement. Okay, even though the amount of time that you spent in London, in my example, is the same. The fact is that if you only had a work permit or student visa, if you didn't go to school and you had a student visa, you would have been deported or kicked out or not had authorization to stay there. If you didn't work or quit, you wouldn't have had authorization to stay there. So there's very good arguments that can be made that regardless of how long you actually were in a third country, that if you did not receive the residency or the citizenship, that you have not firmly resettled there. Firm resettlement is not just a matter of time. Okay, so the longer you stay, the more you can claim you're firmly resettled. No, I mean, it's certainly a factor, and the other side will argue all those years may indicate firm resettlement, but there's lots of case law, statutes, regulations, and so forth that would indicate that if you basically are deportable or unlawful, should something happen, then you're not firmly resettled. So keep that in mind when applying for asylum, and don't just decide not to apply because you might have been in a third country for quite a while before getting to the U.S. Okay, if you like the video, click like, subscribe, and more on the coming videos. Thank you.